Hello, LiveLaw viewers, and welcome to Courts Today. Here are today's top legal headlines. The Supreme Court has today said that appearance of only advocates physically present and arguing in court and one advocate assisting in court will be recorded. Centre has told the Parliament that there have been 2 convictions in the 193 ED cases filed against political leaders in the last 10 years. The top court is set to hear pleas challenging Election Commissioner's law on 16th April. According to the Supreme Court, there can be no blanket nod to establishment or expansion of MSMEs in Taj Trapezium Zone without pollution check. The Delhi High Court has issued a notice on a PIL to reduce bird strike with aircrafts and close illegal slaughterhouses near IGI Airport, and saying that some states boast of high per capita income yet say majority in poverty. The Supreme Court has questioned if scientific criteria is followed for below poverty line. I'm your host Urvashi Chauhan, bringing you the latest updates that matter the most. From key court rulings to significant legal developments, we have it all covered for you. Watch till the end for a complete roundup, and if you find this update useful, then make sure to like, share and subscribe. In an important update, the Supreme Court has issued fresh guidelines on recording advocates' appearance during hearings. A bench of Justices Bela M. Trivedi and Satish Chandra Sharma clarified that only senior advocates, advocates on record or arguing advocates physically present in the court will have their appearances recorded. Additionally, one assisting advocate per arguing lawyer will also be noted. The court emphasized strict adherence to Supreme Court Rules 2013. The directions include that AORs must certify the proper execution of wakalatnamas. If a client signs the wakalatnama in front of an AOR, the AOR must confirm that it was signed in his presence. If the wakalatnama was already signed before a notary or another lawyer, the AOR must verify it and note that he is satisfied with its authenticity. AORs must submit appearance details online via form number 30. Court masters must ensure only arguing advocates and their assistants are recorded. If there is a change in the AOR or the arguing lawyer, an updated appearance slip must be filed, and that senior advocates cannot appear without an AOR. With these directions passed, the bench has dismissed a plea by the Supreme Court Bar Association and Advocates on Record Association. They had sought clarification on the September 2024 rule that only lawyers who actually argue or appear in a case will have their names recorded. This rule, if you recall, was introduced after the case of Bhagwan Das versus State of UP, where a fake petition was filed using forged signatures, leading to a CBI investigation ordered by the court. To read about this in detail, you can visit livelaw.in. In another important update, the Union government has informed the Parliament that the Enforcement Directorate has registered 193 cases over the past 10 years against political leaders, out of which 2 cases resulted in convictions. No case has resulted in acquittal on merits. The Ministry of Finance made this statement in response to the queries raised by CPIM Rajya Sabha MP A.A. Rahim. Rahim had sought to know the number of ED cases registered against MPs and MLAs and local administration members in the last 10 years, along with their party, state-wise and year-wise. In response, Mr. Pankaj Chaudhary, Minister of State in the Ministry of Finance, has stated that the data of ED cases registered against MPs, MLAs and local administrators along with their parties state-wise is not maintained. However, a table containing the year-wise details of cases against existing and ex-MPs, MLAs, MLCs and political leaders or anyone affiliated with any political party during the last 10 years was given. As per the data, there was a spurt in the number of ED cases during 2019 and 2024 period, with the highest number of cases, that is 32, being filed in 2023-2024 period. The minister replied that 2 convictions had been secured in these cases, one each in 2016-2017 and 2019-2020 period. Further, to the MP's query whether there has been an increase in ED cases filed against opposition leaders in recent years, and if so, the justification for this trend, the minister replied that no such information has been maintained. Let me tell you here, the Supreme Court has repeatedly raised concerns over low conviction conviction rates in the money laundering cases. In November last year, while hearing TMC MLA Partha Chatterjee's bail plea, the court had remarked on ED's poor conviction rate and questioned how long an under trial could be kept in custody. Earlier, it had noted that out of 5,000 cases filed by ED in the last decade, only 40 led to convictions, urging the agency to focus on quality prosecution. In the Arvind Kejriwal's case, also the court had highlighted gaps in PMLA arrests and called for a uniform policy. Moving ahead, the top court has today scheduled hearing of pleas challenging constitutionality of the Chief Election Commissioner and other election commissioners' appointment, condition of service and term of office act 2023 for 16th April. The petitions listed before a bench comprising Justices Surya Kant and N.K. Singh contest the removal of Chief Justice of India from the selection panel responsible for appointing election commissioners. As per the law, the election commissioners are to be selected by a panel comprising the Prime Minister, a cabinet minister and the leader of opposition. Advocate Prashant Bhushan, appearing for the Association for Democratic Reforms, mentioned the matter this morning, requesting for a priority listing on another day since the matter listed as item number 38 today was not likely to be taken up due to court's packed schedule. Justice Surya Kant cautioned against frequent accommodations but ultimately scheduled the matter for 16th April. He noted that the court would ensure minimal urgent listings that day so that the case can be heard at the start of the proceedings. In another update, the top court has refused to grant blanket approval for establishment or expansion of micro, small and medium enterprises or MSMEs in the Taj Trapezium Zone without assessing their potential to cause pollution. A bench of Justices Abhay Oak and Ujjal Bhuya stated that such permissions cannot be granted without specific details about the industries involved. The court emphasized that it needs to be informed whether a particular industry is polluting or not before granting such approval. The court here was hearing an application filed by the Zone Authority in the MC Mehta case, which sought modifications to a previous order that restricted new industries in the zone. The court reiterated that no new industries or expansions could take place in the zone without prior approval. It also indicated that the Central Pollution Control Board might be directed to inspect industries to determine the extent of pollution caused by them. In a related matter, the court has directed UP Jal Nigam and Agra Municipal Corporation to fully comply with its earlier directions regarding desilting of the Yamuna riverbed and tapping of untreated drains. The authorities were ordered to submit compliance affidavits by 21st April 2025. Additionally, the court imposed a 5 lakh fine on UP State Bridge Corporation for cutting trees in the zone area without obtaining prior permission, instructing the corporation to deposit the amount with the National Environmental Engineering Research Institute within a month. The Delhi High Court has issued notice on a PIL seeking measures to reduce bird aircraft strike hazards and the closure of illegal slaughterhouses around Indira Gandhi International Airport. A division bench comprising Chief Justice Devendra Kumar Upadhyay and Justice Tushar Rao Gadela has sought responses from multiple authorities, including Directorate General of Civil Aviation, Airports Authority of India, Food Safety and Standards Authority of India, the Delhi government and various municipal and environmental bodies. The PIL filed by activist Gauri Molekhi urges authorities to take immediate action to prevent bird strikes and implement a bird avoidance model at IGI Airport, emphasizing that the absence of such measures has led to serious accidents in the past. The plea also calls for FSSAI and the Delhi government to inspect and penalize illegal meat shops and slaughterhouses operating without proper licenses. Additionally, it seeks a directive for the Delhi police to register FIRs and take action against those running such establishments within a 10-kilometer radius of the airport. The PIL also calls for coordinated action through the Airfield Environment Management Committee to tackle bird strikes, including joint inspections and addressing illegal meat shop clusters near the airport. This petition, let me tell you, highlights that from 2018 to 2023, IGI Airport recorded 705 bird strike incidents, more than the combined total across 29 airports in 6 states states, attributing this to illegal slaughterhouses, meat shops, dairy farms, and environmental pollution around the airport. The court has now directed the respondents to submit replies detailing the steps taken to enforce relevant rules and conduct regular inspections. This matter is scheduled for further hearing on 14th May. And lastly, the Apex Court has raised concerns over how some states, despite having high per capita income, still claim a majority of their population as below poverty line, thereby availing benefits meant for genuinely poor. The court questioned whether states follow a scientific method to identify and classify those eligible for BPL benefits, highlighting the risk of undeserving individuals receiving aid while the truly needy remain deprived. The matter before the court pertains to free ration cards for migrant workers and unskilled laborers registered under the eShram portal. The bench, comprising Justices Suryakant and N.K. Singh, is hearing a case that was taken up suo motu during the COVID-19 pandemic to address the plight of such workers. One important issue in this case is whether the ceiling on beneficiaries under the National Food Security Act of 2013, set at 50% of the urban population and 75% of the rural population, can be extended based on updated population estimates. Advocate Prashant Bhushan argued today that due to absence of 2021 census, an estimated 10 crore additional people should be eligible for ration cards and should receive free and subsidized food regardless of existing quotas. An earlier order of the Supreme Court dated 4th October 2024 directed states and union territories to issue ration cards to all eligible persons by 19th November 2024. However, the Department of Food and Public Distribution later sought permission to comply strictly within NFSA's existing limits. During the hearing, Justice Kant observed that he had come across reports about a state being among the top 3 in per capita income, while simultaneously claiming that 70% of its population is below the poverty line. He questioned how states could reconcile such figures, expressing concern that welfare benefits might not be reaching the truly needy. He emphasized that court wants to ensure benefits reach the poorest citizens and is interested in understanding how states determine eligibility for food assistance. At this, Bhushan countered that around 80% of India's population lives in poverty, and while some ineligible individuals might receive benefits, this should not be a reason to deny millions of others their right to free ration. He also pointed out that eligibility under eShram portal is based on self-declared income and specific criteria set by individual states. Justice Kant acknowledged the critical importance of providing affordable food to ensure that poor families can at least have 2 meals a day. However, he stressed the need for clear scientific data on how states classify poverty and ensure a ration distribution is free from political bias. The court is set to continue hearing this case in the coming weeks.